A man charged with manslaughter asked the judge for one thing: permission to drive again. But when the court uncovered years of speeding violations and multiple crashes, the hearing took an unexpected turn. Did the judge give him another chance, or put public safety first? Stay until the end to see the decision and the surprising outcome of another defendant's case that followed.
Oh, it's lots of pages. All right, let me hold this for a minute so I can go through that. I did not see it. I said, no, you did. Well, I can't use this. I need, if they're going to do a response, I need it before. No, it's not you being sorry. I don't need to. This is Mr. Coleman's case?
Yes, sir.
Are you prepared to argue?
Yes, sir.
Okay, I'm not going to, this was filed this morning, so I'm not going to take. Come on back up. Let's do it. All right. So you're Larry Fletcher Jr.
Yes, sir.
And this is cause numbers 25 DCCR 0838 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon and manslaughter. There's a motion that has been filed to modify the conditions of bond. That he cannot operate a motor vehicle. And so, Mr. Gertz, go ahead.
Judge, I think you're familiar with the facts of this case because we had a hearing on a motion to revoke probation. And the issue in that hearing was about causation of the accident. And the court decided that the issue was serious enough to hold that in abeyance pending trial of these two cases. And my request here is based on the fact that Mr. Fletcher has been following all of these bond conditions, following the rules the court set. But is having difficulty getting to and from work and doing other things that he needs to be doing to be a productive member of society. And he's not allowed to drive. And so, this was not an alcohol, like it's not an intoxication manslaughter case. It's just a manslaughter. It's just an allegation of reckless driving.
The problem is the history of reckless driving. And so what the state has provided, it looks like, is that there was a 2010 non-injury crash, 2012 non-injury crash, a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater than 15 miles over, 2018 a non-injury crash, 2021 a non-injury crash. Based on my knowledge, what was presented at that hearing, regardless of causation, there was definitely a speeding issue. That was clear from the black box in the testimony, that there was a large speeding issue. And so I am not inclined to change the bond. Mr. Nichols, does this?
That was the basis of the state's argument, Your Honor, was that his history of crashes and speeding poses a danger to the public, and that's why we were opposed to altering these conditions.
Yeah.
Judge, we were just alerted to all of that at the same time the court was, that was filed Friday afternoon at 4:00. So.
Well, it is what it is. If there's something in there that you find that is not accurate, then just let me know. File a supplemental motion. But at this time, I'm going to deny the motion to modify the bond and conditions. We'll get it set. It's already on the trial docket.
It is, Judge.
All right, it'll go back right on the trial docket. And again, if there's something that's changed that's not correct, let me know.
Okay, and I think Mr. Coleman has filed a supplemental motion to revoke probation too, which will have to be heard at some point because we're going to plead contrary to that as well.
We'll go over any motion to revoke after.
He may not have filed it yet. He may have just told me he was going to file it. But.
So. That the only two cases are on here are the trial cases, not the motion to revoke cases on our docket, correct? Okay. All right. If something comes through that I need to hear, but my my thought is still to go forward with the trials first and then to deal with the probation,
I understand.
unless there's something else significant, another new case or something.
I'm not aware of anything, Your Honor.
Okay.
Well, let me back up and say, it's not a new case. In the wake of the motion of probation hearing, Mr. Coleman filed a federal case relating to the
gun that
other
was
thought.
found.
Yeah.
Okay.
So and he's not a convicted felon. But we'll argue that when it's time to argue that. But that's what the new case is.
Okay. That was something that I've already heard in that motion to revoke. To some extent.
Correct. Yeah.
Okay. All right. We'll see you back at the trial date then. Good morning, sir. You're Brian Battle. Good. And Mr. Battle was previously here in court, entered a plea of guilty in clause number 25 DCCRs 1050 to evading arrest or detention with a motor vehicle. I received that pre-sentence report. Has everyone had an opportunity to review it?
Yes, Your Honor. I have good.
Are there any additions or corrections?
None from the defense, Your Honor. Judge, only I would like the court to know, on the defendant's behalf, he is a veteran. He's
I
already
have
lived
let
in
I've already
with the VA. He's already working with them, so I
Good.
wanted to invite him to either come and observe our docket on June 17th, or if it would be okay with him, I will have Ms. Lowe reach out once he gets established on probation. Let him know what we have and we can help him with from that end, maybe
Yes.
even to get his probation. I would certainly agree to an early termination if the court would, if he successfully completes that after 2 years. I want to make it
Right.
available to him, but
So
I don't
there's a
want-
veteran court program. That's a great program. That's what Ms. Molfino is talking about. And so you can go through that program while you're on probation, and it can help you with everything that has to do with your veteran stuff, in addition to what you're already doing, and it can help you get off probation early as well. So it's definitely something. Ms. Holmes can get that date and get you signed to go at least look, but I would strongly suggest you go through that program. It's a great program.
Yes, ma'am.
Okay, good. So, I'm sorry.
I'm about to say I didn't know nothing about it. They don't really tell us it's that.
Right, and it's something that kind of happens up here, and as soon as I saw, some that your duty and what's going on with you, and that I made a notation of veteran court on here, so it's a great program. So I'm going to find Mr. Battle that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity. You won't have a felony conviction on your record. And at the end of your probation, the case will actually be dismissed. You'll never have the conviction. The other side of that, however, is if you violate any condition of probation, then you could be back in court, found guilty of the offense, and sent to prison anywhere in that punishment range, which is between 2 years and up to 10 years in prison. So it's, again, get that information from Ms. Holmes and Ms. Malfino before you leave today. And that way you can go to that first, the one that's coming up pretty soon, and hopefully get signed up and go through that program as well. All right. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you waive the right to appeal. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go for all your paperwork. All right. Good luck to you, sir.
You know,
What do you think? Should someone with this driving history be allowed back behind the wheel before trial, or did the judge make the right call? Drop your opinion in the comments below. If you enjoy real courtroom moments, legal decisions, and case breakdowns that make you think, make sure to subscribe, turn on notifications, and join our community for more powerful court stories every week.